Hello everyone and welcome to today's Mondac webinar in association with Bull Blockchain Law LLP, focusing on crypto assets and Web3 in 2023. I am joined by the brilliant Andrew Bull and Tyler Hartdraft to guide us through today's discussion. But before I hand over to Andrew and Tyler, a housekeeping item. You can submit questions to today's presenters by typing them into the questions pane on the control panel of the right-hand side of your screen. We will endeavour to answer as many of your questions as possible during our Q&A session, but please do reach out for any additional information you may require. It's now my pleasure to hand you over to Andrew and Tyler to begin. Thank you.
Thanks, Dan. Appreciate it, and appreciate Mondac for hosting as always. Looking forward to the presentation today. Today, our topic is crypto assets and Web3 in 2023, kind of an update for in-house counsel, founders, and investors. Our main goal is really to kind of dive into the substantive legal questions that a lot of the stakeholders in the industry have and try to provide some regulatory clarity, not only in the United States, but also in a couple other jurisdictions as well. And really the main takeaways are just to provide some type of insight into what are the considerations that go into operating in the industry. For those who are considering getting into the industry, what are those types of considerations? And then really kind of the forthcoming legal questions that we might see answers to in either the short term or long term. So with that in mind, just giving a little bit of background about ourselves for the next slide. Tyler and myself, we actually started on the tech side of this industry. We ran a cryptocurrency mining company as well as an investment fund, and doing the legal work for those companies, we transitioned over to the legal side in 2017, 2018, and launched the firm to address kind of an open-ended need for legal clarity, not only from a regulatory standpoint, but also a kind of pure legal standpoint. Fast forward to today, we have clients in the United States, but also in foreign jurisdictions, and our clients are quite diverse in the sense that they're in kind of all the different pockets that are in the blockchain and cryptocurrency industry. So everything from mining to payment providers to exchanges to companies that are just utilizing blockchain tech and not even on the crypto side, and so on and so forth. I myself am also a professor. I teach blockchain and cryptocurrency law at Drexel University's law school in Philadelphia and Pennsylvania in the States. Next slide, please. So like I highlighted on the first slide, the main goal is to provide some regulatory clarity, some insight into the ongoing legal cases, as well as legal cases that we've gotten decisions from, especially in relation to probably who is considered the most adversarial governmental agency against this industry, and that is the SEC. So we'll talk about some of the administrative rulings that they've facilitated, as well as some of the litigation cases that are either ongoing or have transpired, and really trying to provide more of an update, because we have background and we've had given other presentations on Mondac where we get into kind of more of the high level insight in terms of kind of the 101 aspects of the industry. And really here we kind of want to take the next step and get a bit more substantive so that individuals or stakeholders or entities, whoever is going to be using this information, can kind of have that backdrop of introductory information and then be able to kind of take the more real substantive steps in terms of maybe specific questions that you have around the industry, or maybe questions that come up for the businesses that are operating in the industry. So within that, thinking about potential legislation that is being proposed, not only in the States, but also in the EU, as well as crypto regulation as a whole. And then, like I said, the litigation cases that we're going to talk about. Next slide, please. Just from a high level perspective, I wanted to note a couple different use cases that we'll definitely cover, because we really want to try to combine this regulatory legal clarity with practical case studies within the industry that we experience as practitioners representing clients from a lawyer perspective, and just seeing kind of those main takeaways that really are intended to allow for companies to kind of not make the same mistakes that companies have made in the past from a legal regulatory perspective. So a lot of kind of these overarching categories where our clients are either interacting from a service provider perspective, or maybe they're launching some type of technology that blends into one of these more traditional industries, a lot of the use cases that we're going to tap into and talk about are really from the perspective of, is there a digital asset involved? What type of the iteration of blockchain is being utilized in this situation? And then what are the potential regulatory risks and then risk mitigation strategies? Because I think that it's a multi-step process in terms of doing your own risk analysis around whatever your business or operations are. And that starts even from the perspective of entity structuring, formation, jurisdictional considerations, and then also obviously user interaction, so on and so forth. So just highlighting finance as kind of a general category, right? We have tokenization of real estate as kind of a specific example whereby the tokenization of securities as a whole has definitely taken flight in terms of the industry. And there is this conundrum that we'll get into from a substantive perspective, where a lot of companies that have already issued tokens have significant open-ended questions around whether their tokens are in fact securities, and whether they either took proper precautionary measures or whether there is a path for companies to be able to issue an asset that is accessible in these larger jurisdictions like the United States and the EU. So peer-to-peer lending and stablecoins are also in that category as well. We have a lot of regulatory clarity or insight in relation to how stablecoins operate. And there are a lot of businesses out there, especially what we call money service businesses, that are very much focused on how to deal with being a service provider in the context of stablecoins as well as the lending industry. And then we have other areas that this is definitely impacting. I mean, digital assets as a whole has really expanded exponentially over the last 5 or 6 years from a legal standpoint, in that now we have iterations of royalties, social impact and sustainability, carbon credit, tokenization, education rewards. Decentralized autonomous organizations have taken flight in their application, not only in the kind of DeFi, decentralized finance context, but also in the more kind of traditional finance and then also business operation context. And so other categories like identity validation, and another specific example is definitely insurance, where we're seeing the utilization of this technology. And then taking a step back and just highlighting that for us who are operating in the industry and kind of boots on the ground, we really see blockchain adoption kind of happening in the background to a certain extent. And then a lot of the regulatory questions bleed into more traditional areas of law, like privacy. GDPR is a massive consideration for a lot of our clients, especially around the accumulation of information. And in addition to that, we also have a lot of scenarios where there's multiple legal jurisdictional considerations that factor in to the ultimate decision that is made by one of our clients. For example, if I'm launching a tokenized investment fund, or maybe a mining company or something along those lines that is going to be in multiple jurisdictions, or maybe I'm launching the next kind of play to earn game in the Web3 space that is going to allow users from multiple jurisdictions. Each iteration of these kind of companies that are in the industry have different legal questions and considerations. And with that, we'll go on to the next slide, and I'll let Tyler kind of jump into some of the actual crypto legislation that exists, and then we're going to get into some of the very real world cases that exist as well.
Thanks, Andrew. Yeah, so we'll talk about kind of the history of crypto legislation, and you can see here in this chart, there really was not much activity in the early years. Crypto was not getting a lot of attention. There's a little spike in 2017, and if you'll recall, that was the year that the Dow report from the SEC was first published. 2018, we had some interest in legislation. 2019, another spike. But things really accelerated in 2021. And we're going to talk about some of the major legislation that was put forth in the tail end of 2022, and a major piece of legislation that's been proposed in 2023. And so just to give a little bit more context, we really are truly at an inflection point in the US with crypto regulation. There's several important issues before the courts related to DAOs, exchange liability, token designations, regulatory oversight, jurisdiction, and consumer protection. And so Congress has shown a growing interest in regulating crypto assets, which has only accelerated since the fallout of FTX. And this is positive because we need fit for purpose rules. We need a registration framework for crypto asset exchanges. and appropriate disclosure requirements for crypto asset issuers that really considers the unique nature of crypto assets. And so absent rulemaking by our regulators, Congress is required to step in, and that's what we've seen in 2022 and 2023. And so just to go to the next slide and talk about major crypto legislation from last year, there's really three main bills that were proposed that really cover a lot of ground. And so the first one of those was the Digital Commodity Exchange Act. And that sought to do a number of things, but here are the highlights. So it sought compliance procedures to be implemented by crypto companies. It sought to preempt state laws on numerous issues. It put forth consumer protections for various crypto businesses to comply with. And it had core principles for risk management and antitrust considerations. Some of the criticisms of that bill were really that it created loopholes for digital asset related businesses that they could exploit. Also that it didn't create proper frameworks for regulation, and it just was overall seen as giving too much leeway and not addressing core issues. And so notwithstanding, it really was a foundational bill that would serve a great purpose for advancing more recent legislation, including bills like the other two named on this slide, the Lummis-Gillibrand Responsible Financial Innovation Act and the Digital Commodities Consumer Protection Act. And so the Lummis-Gillibrand Responsible Financial Innovation Act was a major piece of legislation. And among the bullet points here, it also set out to preserve much of the SEC's function with respect to assets or investment contracts that truly were securities. It expanded the CFTC's authority to provide exclusive jurisdiction over digital assets. So the SEC would have jurisdiction over assets that were securities. The SEC would have jurisdiction over assets that were considered commodities. And so assets that the SEC would have jurisdiction over included equity interest, liquidation rights, dividend payments and promises or profit shares, all of the things that the SEC has traditionally regulated and that have been within the SEC's jurisdiction. And then what it did was divide the authority between the SEC and the CFTC for ancillary assets, which were understood to be intangible, fungible assets. And so there's this middle ground where an asset may be a security to start, and it may evolve into a commodity as a company decentralizes. And this idea is really that the SEC would still have jurisdiction over disclosure requirements imposed on issuers. So whether or not that a token was issued, there may be an investment contract at issue that requires disclosure. And so that token might not necessarily represent the investment contract. It might be a commodity sold in conjunction with an investment contract. And this really underlies the theory that's gaining a lot of traction. The tokens and any instrument does not necessarily embody an investment contract. And so the Lummis-Gillibrand bill was really important for all of those reasons, and a really foundational piece of legislation that the 2023 legislation we're going to talk about pulls a lot of ideas and concepts from. The Digital Commodity Consumer Protection Act, it did a lot of similar things. So it talked about CFT having exclusive jurisdiction over crypto assets as opposed to splitting jurisdiction with the SEC. It provided core definitions for digital asset terms like digital commodity, custodian exchanges. It provided rules governing margin and leverage trading. We've seen a lot of CFTC enforcement actions against decentralized protocols that permit peer-to-peer trading of these margined and leveraged assets. So that was an important rule to address. And it also provided custodian qualification requirements for consumer protection purposes. So some commonalities among all three of these bills that we see is really segregation of funds. That's continues to be a major issue since the FTX fallout. And if you read through the complaint by the SEC against Binance, you see that's a point that's really hammered on time and time and again in those allegations as far as what Binance was and was not doing with customer funds and who was in control of them and where they were held. Another commonality in the bills is really requiring financial resources and system safeguards, and then this idea that we need to figure out the power balance between the CFTC and where the jurisdictional lines should be drawn. So moving to the next slide, we're going to discuss the major crypto legislation that was introduced this year, which is the McHenry-Thompson bill. There's a discussion draft that was published on June 2nd, so it's a very recent bill. It's a very substantial bill in that it's 162 pages, so about 20% or so of the Dodd-Frank Act, which is obviously one of the most major pieces of financial legislation in most of our lifetimes. And so this bill really set out to do a lot. First, it provides a lot of core definitions under the Securities Act of 1933 and the Commodity Exchange Act. Some of those different definitions it sets out to provide are definitions of blockchain, definitions of a decentralized network. So that definition is any network that doesn't qualify as decentralized if during the 12-month period any issuer or affiliated non-decentralized organization has 20% of the beneficially owned units. And so what that's saying is we need to make a determination as to when a project is decentralized. And there's been a lot of back and forth about can a project become decentralized over time, and at what point does the token that it issued not be considered a security anymore. And so this tries to put hard and fast rules by implementing a 20% threshold. This bill also establishes reporting requirements. So digital asset issuers having to file reports regarding certain conflicts of interest, ownership of assets. This needs to be filed with the SEC under this bill. And the digital asset issuer must also file annual and semi-annual reports. And so this has been an item that has gotten a lot of attention. A lot of issues stemming from misrepresentations and failure to disclose information. We obviously want purchasers of digital assets to understand what they're buying and what the sponsors of that asset really own and what they're going to do with that asset or the network that it's building. So reporting requirements has been a mandate for legislation since a long time. It's also discussed the registration of intermediaries. So any intermediaries that are involved in the offer or sale of a unit of a digital asset under this exemption must be registered with the SEC. It defines a unit of a digital asset acquired from the digital asset issuer in reliance on this exemption is going to be deemed a restricted digital asset. So we have a lot of good lines being drawn as far as reporting requirements, registration requirements that are really important to the operation of this industry and the intermediaries in this industry. Many of whom are impacted and are on the sidelines of much of the regulatory enforcement actions that have been brought forth by the SEC. And so when I talk about an inflection point, it's really just this idea that we're finally having conversations in Congress and we're having cases go before judges that are addressing many of these issues that have long been a strain on the industry. So if we go to the next slide, we're going to talk about crypto regulation as far as some rulemaking. So the SEC recently requested comment for a proposed amendment to Rule 3B16, which sets forth the definition of an exchange. The key change here is that the SEC is looking to regulate generally speech, something that's considered speech and not conduct. And so if you look at the original two-part test for an exchange, this includes a group of persons that brings together orders and uses established non-discretionary methods for trading and the interaction of such orders. That has been the definition for a very long time, but the SEC, in recognizing that it wants to regulate decentralized exchanges or DeFi protocols, has set forth to expand the interpretation or definition for exchange and expand its power over these protocols. And so what it's done is it's proposed a new rule that defines communication protocol systems that bring together buyers and sellers of securities and makes available trading methods and rules. And so the key change here is the decision to regulate decentralized finance protocols. And there's been a lot of comments from policy organizations that have been published in response to the original proposal and a reopened comment period on this issue. And the overall sentiment is that this would essentially be a death knell to DeFi. There's some of the criticisms I list out on the next slide, key takeaways and critical comments. This is going to be a problem because of broad and ambiguous terms that are in this rulemaking proposal. So several perspectives list the fact that there is not a definition for an organization, association, or group for determining how this rule will impact DAOs. And if you have a rule that you can't really apply because you don't have a fitting definition, then you're not really putting the industry on notice as to how to be regulated and how to comply. This, as well as the fact that there's no definition of control or of communication protocols for purposes of determining applications to DAOs, this is an issue as well. And so the injection of these broad and ambiguous terms serves to further the SEC's purpose of being able to regulate these organizations, but it doesn't necessarily put the industry on notice. And so, like I mentioned, some of the criticisms, this regulates speech, not conduct. Certain commenters have pointed out that the regulatory changes are beyond the SEC's authority, in that the SEC does not have the authority to regulate non-security crypto assets. So essentially, this rule would allow the SEC to regulate decentralized exchanges as long as those exchanges trade any crypto assets that are considered securities, regardless of their trading, their paired trading of non-security crypto. So as I mentioned, the SEC has resumed many critical comments from policy groups about this rule change. It's something that everyone in the industry is watching closely and should definitely be aware of, especially if you are advising decentralized finance protocols or participants or developers, because liability can most certainly fall on developers with this rule change if it is implemented. And so we expect this will have a potential chilling effect on participation and innovation. So jumping to the next slide, one other major development as far as crypto regulation and rulemaking was Coinbase's proposal for rulemaking. Coinbase put forth a proposal in 2022 for the SEC to make rules regarding a number of rules in the industry, primarily regulation of crypto asset exchanges. The SEC has not engaged in any rulemaking. Coinbase sued the SEC by filing a writ of mandamus, essentially demanding an answer on whether or not the SEC has made up its mind as to rulemaking. The SEC recently responded, stating it would provide a substantive answer within 120 days. And this case is ongoing in the Third Circuit. And so, as recently as this month, there have been filings in this matter. And the Third Circuit recently stated it was retaining jurisdiction to ensure the SEC responds timely. So why is this important? It seems like kind of an ancillary matter, but I think it's important because, it really illustrates the fact that the SEC is willing to go out and sue major exchanges, but not willing to put itself on the record as far as whether it has made a decision as to rulemaking. And this really impacts litigation strategies. So for the litigators out there, or those advising companies that are involved in litigation with enforcement agencies, it serves as an important reminder that the Administrative Procedure Act is relevant. And so to the extent that that can be wielded as a sword, like Coinbase is using here, it certainly should be considered. And so the SEC can simply comply by simply answering whether or not it's made a decision here. I don't think the idea is that Coinbase expects a substantive response on any rules. The idea is that Coinbase wants the SEC on the record as having made up its mind to make rules or not. And so that's really the sword that's Coinbase is using the APA Act for there. So we'll touch on tax a little bit as well. This is very recent. The IRS requested comments regarding the taxation of NFTs. And so a little bit of background on the request for comment. The IRS intends to issue guidance related to the treatment of certain non-fungible tokens. So it intends to treat those tokens as collectibles under the IRC, including guidance on long-term capital gains rates. And so this is going to be an important piece of legislation or guidance really for how to interpret taxation of NFTs. And the key takeaways from this and several comments that have been put forth is, whether and to what extent NFTs are subject to broker reporting rules, and how you look at an NFT to determine really what it is and what the tax impact should be. And what the IRS has suggested is that there will be a look-through analysis, essentially looking through to the underlying use of the NFT. Commenters have pointed out that these NFTs are digital assets and the use can change. So you might have an NFT that represents one thing one day and the use changes over time. And so how do you account for that in your tax analysis? Under the look-through analysis, an NFT constitutes a collectible if the NFT's associated right or asset is a collectible. It's a little bit circular here, so there's some things to work out as far as the IRS's treatment, but mainly it's unclear how the analysis treats digital files. And so, sure, if something represents a collectible in real life, that makes sense. It should be treated as a collectible, but we don't understand really how this impacts digital files at this point. So I'm going to toss it back to Andrew to start us out on crypto litigation. We have a lot of cases to discuss here, both from the regulatory agencies and states and private as well.
Thanks, Tyler. Appreciate it. And I think it's important to kind of contextualize or compartmentalize out the different governmental agencies like Tyler just highlighted in terms of the ongoing litigation, because the outcome of each of these cases is highly dependent on the governmental agency that has brought that administrative ruling against the company or the exchange or whoever it is. And again, what we just went over in terms of the different areas, like if you have exchange regulation versus an issuer of a token regulation, there's some interconnectivity for sure, but also thinking about these cases through the lens of whatever party you're either representing or a part of is really important, because somebody who's issuing a token is going to have different considerations than somebody who's, say, for example, is launching an exchange to be able to allow the facilitation of trading tokens. And then even more different is somebody who's maybe launching some type of online service or Web3 kind of game or something along those lines, or ecosystem that allows for the interaction with individuals and or entities through whatever services they're providing. So thinking specifically about the litigation that is not only has transpired but is ongoing, we'll start and focus with the SEC, just because that is definitely the most prominent. As I said before, they're definitely the most adversarial governmental agency towards the industry, and therefore there's a plethora of litigation that is ongoing. I think it's important to distinguish as well, and I'll get into this in a couple of these cases, is it's really important to identify what the managerial component is of the company that is at issue. So if you have a company that has issued a token, or say in the exchange context, what is the control aspect of the actual assets? Because with the advent of blockchain, there's now a whole slew of examples that it's really on the individual in terms of the control over their assets. I bring up MetaMask as a really good example of a quote unquote wallet that is not centralized, it's decentralized, meaning that the sole controlling party of that wallet is the individual. And that's really important in relation to how the MetaMask wallet not only was developed, but also deployed, and so on and so forth. And so when we think about from the lens of what the actual company is at issue, we want to get a little bit more substantive on what that element of control is from an asset perspective. And again, I highlight the kind of quintessential example of managerial responsibility over someone's finances. A lot of times that's reserved for a fund or maybe a registered investment advisor or another party that is offering financial services in that context. And so there's implications in terms of what the actual control over the asset is, let alone also identifying what the asset is defined as under our traditional definitions of securities, so on and so forth. So with that, we'll get into a couple of the SEC litigation cases, and we can jump to the next slide. So the first one that we're going to highlight is the SEC versus Payward Ventures, which is commonly known as Kraken. The Kraken exchange is one of the largest cryptocurrency exchanges in the world and has a significant presence in the United States, as well as a lot of other foreign jurisdictions like the EU and Asian countries and so on and so forth. So one of the issues that they encountered with the SEC was around their staking as a service program. And so this isn't necessarily an issue in relation to the ability to do what we call spot trading. For example, if a user logs on to Kraken, creates an account, gets their identity verified, then they can deposit assets from their bank or maybe from another payment provider and then be able to trade cryptocurrency. So that was not actually what the issue was in this case with Kraken. It was that Kraken released a program for allowing that individual user to not only spot trade, like what I just described, but also being able to stake. And staking, for those of you who don't know, is a process that is very technical in nature in the blockchain context and can be done by anybody. But what Kraken did is they basically said, hey, if you're a user on our platform, you're going to be able to take your assets for certain types of assets on the platform and be able to stake them through our exchange. So it's really important that we identify that specific point, because if somebody goes off and they access, say, for example, the Ethereum blockchain, which is one of the most popular, well, it was in terms of kind of how mining was and then transitioned to staking, but is becoming more and more popular from a staking perspective, that they can just do that. And we're not necessarily in this realm of regulatory consideration from the SEC's perspective. But when you layer in Kraken in this example, and they have some type of managerial effort over that program, that's where it gets complicated. And the SEC has really come after a lot of different companies for these ancillary service products that are akin to some type of investment opportunity where the individual is really reliant on that exchange to be able to generate some type of profit in that context. I'll also throw in this consideration that if the income that is derived or the profit that is derived from that service is passive in nature, that presents even more of a problem from the SEC's perspective, because there's no active role that the individual user has in whatever that service is. And that bleeds into how we define whether an asset is a security and supports the ultimate conclusion that it potentially is, like Tyler was referencing in the investment contract context earlier. So the facts right here, Kraken launches a staking as a service program. Individual investors or also institutional investors. Again, there's companies that open up accounts with Kraken. There's also individuals. They're able to take their tokens and essentially click the staking button and then be able to actually stake their assets. So the SEC ultimately determined this is an unregistered security. They fined Kraken. Kraken ended up paying $30 million in disgorgement, prejudgment interest, civil penalties, which is kind of a drop in the bucket for them from a high level perspective. I'd say the larger loss for them is the amount of profit that they were generating from the staking as a service program. And so I also want to put that into context in terms of Kraken most likely was like, yep, we'll pay this fine, cost of doing business. Look how much money we've made off this prior to this. Definitely significantly more than 30 million in terms of fines. And as a result, it kind of worked out for them, for lack of a better term. And so when getting into the staking program, the specific facts of that case, the SEC, they highlighted several of these efforts, these kind of essential managerial efforts that throw us into the realm of, oh, we have a manager involved in this actual transactional timeline, rather than that kind of traditional peer-to-peer example that I described with MetaMask. So Kraken was able to determine how many tokens to actually stake, how many tokens to reserve in order to provide instant unstaking. So what that means is they allocated separate tokens to allow for, if you as a user wanted to remove your tokens from staking. One of the conundrums that Kraken was facing is that on the technical side, a lot of the tokens that are allowed to be staked via the blockchain, you can't just pull them out immediately. So there's a whole process to it, and it creates delays and time. And as a result, Kraken didn't want to have this whole scenario where they're just having their users wait around. So they're like, well, we'll put up basically the quote unquote collateral to be able to allow somebody to unstake and get their liquidity back almost instantly. And that's a pretty significant portion of the service that was provided that really shifted into this much more kind of essential managerial efforts context. The other factors as well that contributed are staking investor tokens. They were operating nodes, so they were actually running nodes via the blockchain. And what that means is that that's a much more technical side of how the actual process of staking works, which means that, and the SEC most likely didn't get the opportunity to pose these types of questions because ultimately Kraken decided to pay the fines and just kind of throw their hands up and say, hey, we're not going to offer the product anymore. But if they had gone into, say, court and really battled it out on a much more kind of extensive litigation side, they would most likely ask questions around, okay, well, what happens if these nodes that Kraken is operating fail? Is that going to impact the assets that the individual user is in fact being subject to via the staking on the Kraken platform? The answer is without a doubt, no, absolutely. And so again, bleeding into that kind of more control aspect of the actual facts of this case. And then really the determining of the pro rata investor returns, distributing those investor returns. If they really wanted to, there's a common term in the blockchain and cryptocurrency industry that is not your keys, not your crypto, which essentially means if you have a wallet on an exchange or an account on an exchange, you ultimately don't have full control over those assets because the exchange itself actually has the ability to prevent you, say, from withdrawing them. So when they're making these determinations, like how much investors are actually going to get back via the staking, you could go on their platform and see the percentages actually change. Well, that's potentially problematic because, again, more towards the notion that they are in fact dictating how this process is occurring. So we'll jump to the next slide, and really the main takeaway there is that these additional investment products where there's kind of overarching managerial efforts by the exchange are definitely problematic from a securities perspective. Switching the lens of where the SEC is analyzing who is actually responsible for the potential violations of the Securities Act, we have the library case, which is the SEC versus library. So LBRY is the token that was issued by a group of individuals. And the interesting thing about this case is that issuance actually occurred way back when, during the ICO boom of 2017. And it took almost 5 years for this company to come under fire with the SEC, but also shows that there are a lot of companies that are operating and have been operating for years that have issued tokens themselves that, while they haven't come under the fire of the SEC or another governmental agency yet, that doesn't mean that they're absolved from liability. And so there's always kind of this potential risk for companies that haven't taken the compliant approach and are basically saying, hey, this token is actually not a security. We disagree with any type of categorization. So in the library case, they were basically advocating that the utility, quote unquote, of their protocol, meaning why they were actually launching the token, was the main purpose of it and not an investment opportunity. And the library company was all about disrupting a traditional financial industry in the loan context as well as the insurance context. And so they were basically claiming that that was their main point of business operations. And therefore, when they actually issued the token, the objective was to allow users to use that token on the platform rather than, say, raise funds like you would in the traditional context. Because if you go out and you just raise funds for your company, right, you sell interest in your LLC or your C Corp shares, et cetera, right? Those are all securities, because at the end of the day, the person's buying into an investment and they're relying on the company to be able to potentially generate some type of income as a return on their investment. Well, one of the issues here was that the library team, they sold a substantial portion of their tokens, but they also reserved a substantial portion of their tokens to be able to use and deploy and control. And again, that control aspect is very similar here, even though we're looking at it through the lens of the issuer of the asset, rather than in the Kraken context, the exchange kind of managerial side of a service. Here, the fact that they were withholding tokens and then we're going to deploy them later on meant that they could influence the market and the actual value of the token. That's really important in terms of a securities designation around a token. And when I get into the next cases or two, it's going to be really important to distinguish away what that means when somebody, say, for example, launches a token that is not in control of them, because a securities analysis by the SEC is very fact dependent, and it's a collection of all facts. It's not like, oh, if you do one thing, then it's a security, or, oh, you did another thing, it's a security. The SEC looks at all the facts, all the communications, and in this scenario, they found that the token was in fact a security because, again, there was this element of control, and also they highlighted a lot of communications that the core founders of the library team published to their general community. So they used language specifically from the perspective of, oh, this is actually something that you're communicating to a third party, a potential prospective purchaser, and then also allowing for them to control the potential influence of the funds that that individual could theoretically access. And again, going back to the legislation that Tyler highlighted earlier that has been proposed, there is clarity in the traditional context in how entities or individuals can issue securities in a compliant way. We do a lot of tokenization work in the compliance side of tokenization, like I was referencing in the real estate context, or if a company wants to tokenize equity, or maybe they want to tokenize shares in their company, right? Or some type of debt, some type of interest, or like intentional revenue that could be generated. Things along those lines, there's a compliant path. It's more that library as a company didn't do any type of KYC, they didn't do any type of investor verification, they didn't confine the offering to the parameters of some of the exemptions that exist for the Securities Act, like Reg D, Reg A, Reg CF. And as a result, they ended up losing their battle against the SEC. And ultimately, LBCs and the library token itself were sold as investment contracts. Next slide, please. So just kind of building upon that and kind of combining the two cases that I just referenced in terms of Kraken and then the issuer with library, what's really interesting about the most recent, and again, this is very recent, as in like in the last month or so, that the SEC is going after exchanges and highlighting specific tokens that are traded on their platform as triggering the conclusion that the exchange is in fact an unregistered securities exchange. And that's a really interesting strategy because in the traditional securities designation context, and this is maybe where we get into our legal opinions as practitioners, where we think that the head of the SEC right now is maybe overstepping his regulatory authority to a certain extent, because they're saying tokens are securities and then justifying going after exchanges when they haven't actually gone through the traditional administrative ruling process to determine that those tokens are securities. They're just claiming that they are in the complaint against the exchange, which is potentially problematic from a regulatory authority approach and really gets into kind of more how administrative law functions and the kind of balances of how much authority regulators have in the United States and abroad. So in this case specifically, we're talking about Bittrex, which is a cryptocurrency exchange, a really significant cryptocurrency exchange that has really since left the United States and was around for a really long time. And again, the SEC is alleging that these 6 specific tokens traded on the platform were in fact investment contracts, and that Kraken was an unregistered exchange, clearing agency, broker, all of these kind of traditional parties that exist in that context that are potentially problematic if you are facilitating these services without properly registering with governmental agencies. So, and again, highlighting that the SEC really focused on that there was an order book, matching engine, liquidity pool. I mean, all of these kind of traditional aspects of an exchange. But the really key point is that there needed to be securities traded on that exchange to change the analysis from, oh, we're not in the traditional cryptocurrency exchange perspective process. We're now in, you're an unregistered exchange. And this is really problematic as from a potential kind of regulatory clarity perspective, and also overemphasizes the need for that legislation to potentially pass or even more substantive legislation. And so in each case, the SEC highlights, except for Dash, which is even more interesting, that they have tokens that were sold to investors, but they also threw in a token that wasn't even sold to investors, which again, going back to what I just talked about with the library ruling, that is really problematic. And so it's interesting from that perspective whether they even think that that token is in fact a security. I mean, clearly they do, but they need to prove that. And we have a whole administrative ruling process in the United States to ensure that parties get to say, from the perspective of whether their token is a security, that they disagree or agree. And like, you can go across all these tokens and look at the market the day that this complaint came out, and they're all down. They're all significantly impacted. And that really just impacts the individuals holding the tokens. Granted, again, like, it would be really important for the SEC to go through the process of categorizing these tokens as securities first and foremost, and then moving into the exchange side. But as a result of kind of this overstepping, we now have a scenario where investors that are ostensibly meant to be protected by the SEC are actually negatively impacted because of a complaint that is filed like this. So in some cases, again, the SEC is specifying that the public sales, and in other cases, the SEC does not specify that the private-public nature of the offering is a factor, which is a little bit inconsistent from our perspective, and we would like more consistency there, or at least from more clarity on why that is happening. So anyways, key takeaway is that they're going after Bittrex for these violations, and it's potentially going to provide some insight into where we're headed from a regulatory standpoint. Next slide, please. So building off that, again, we kind of saw Bittrex as a precursor to a even more significant case, which is the SEC has now filed a complaint against Binance. And Binance is definitely one of the largest exchanges in the world, has significant operations all over the globe, multi-billions of dollars of transactions on a daily and monthly basis. It's really interesting to see the SEC, after all these years of kind of understanding how Binance operates, to go after this exchange, because we, from the perspective of the kind of legal community in this space, really think that there are definitely problems in relation to how Binance has been operating. But at the same time, like, the SEC has been bogged down with like the Ripple litigation, which is a separate case, or other of these smaller administrative proceedings that, again, like, don't really launch into a larger kind of consumer protection focused strategy, and really seen kind of just one-offs from the perspective of what it is that they're trying to establish from a regulatory perspective. So one of the interesting aspects about the Binance case is they looped in the founder, CZ, and they're saying that he's going to be liable for personal liability in relation to not only trading the unregistered securities, which they list, interestingly enough, which is different from the Bittrex situation, is that the tokens that they listed are tokens that are actually issued by Binance. So we kind of have a combination where there's two different lenses to look at, right? We're looking at the lens from the exchange perspective, but we're also looking at the lens that Binance, the entity, well, it's a separate entity, they issued a BNB token. They also have a stable coin in the form of BUSD. There's a vault, there's these earn programs, going back to the Kraken example. And so this is kind of an amalgamation of all those legal issues that I've kind of covered in that context. And it really is kind of, in our opinion, going to be one of the most significant cases that the industry has ever seen. And so key takeaways, again, SEC, this is very early on. We have a long time before we see some very real kind of decisions that come out of this, because we imagine that Binance is going to fight. One of the contextual components here is that they have looped in CZ, but again, because of the jurisdictional authority limitations of the SEC, they're really going after Binance US, because they're going to try to use that as a jumping off point to go into the larger operations from a global perspective. So again, they're identifying BUSD as an investment contract, which again, it's most likely going to be really difficult to prove that, because if a token can't change in value and is pegged to the dollar, we're not really seeing how you could potentially, again, say that that's an investment contract. The products around staking and earning and things like that, yes, that's probably an easier argument to make, but just saying that outright, we think that's kind of difficult. So they added on to their tokens that they put into the Bittrex complaint, listed more. Again, many takeaways from this that are going to happen, and just highlighting that initial point that the majority of these tokens have not come under fire from the SEC, and that's potentially problematic. Next slide, please. So touching on the Coinbase case is also really important, because there is a similar strategy going on from the SEC's perspective, except we think that this is a bit different because one of the kind of components of the SEC's operations is that they went public a few years ago. And so they actually went through the process of being evaluated by the SEC, which is really important from the perspective of kind of notice that the SEC could have given to Coinbase in relation to these potential problems. And now they're a publicly traded company, which presents a whole slew of additional considerations for shareholders, et cetera, et cetera. So this is a bit different from the Binance perspective in relation to that. And also we think that the Coinbase case is more about kind of making sure from the SEC's perspective that Coinbase is staying regulatory compliant and really removing some of their more investor-based products like the Earn product that is somewhat similar to the staking as a service product that I mentioned with Kraken, but a little bit different. Anyways, all of that is to say that the list of tokens now that have been added is even more important from that perspective of, okay, what do these projects now do? Are they going to have concerns over whether these tokens are securities? If this case ends and if falls in the favor of the SEC, would that mean that now those companies need to potentially register? Again, there's a lot of different considerations that are going to be major takeaways from this, but the substantive legal issues are really around the products that are being offered. And also going back to, I mean, Coinbase is extremely active in this space, and they've been requesting regulatory clarity for years from the SEC. To no avail and no response. And when they responded, they eventually actually sued the SEC to try to get clarity. We haven't gotten that clarity yet, and we'll see whether we do, but that's going to be interesting from that perspective. Next slide, please. So before we jump into this, I know Tyler's going to talk about a couple of the CFTC enforcement actions, but I just wanted to kind of touch on this real quick question. It says, do law firms provide crypto analysis and fraud cases, or is it generally outsourced? Yes, without a doubt. I mean, there's a lot of analyses that our types of firms, like our firm and other firms, provide in that context. We can have that conversation offline as well. Feel free to shoot us an email or anything along those lines if you want more information in that context. And then also just an anecdotal note, I think we'll let Tyler do this slide and then maybe jump into a couple of the other questions. So go ahead, Tyler.
Yeah, I'll just briefly touch on this slide and a couple of the cases that we were going to discuss because we wanted to remind of the CFTC enforcement actions because there's been a lot of them, but they don't get as much press as the SEC enforcement actions. All of these actions have a lot in common in that they're regarding the leveraged trading of commodities or crypto assets that are commodities. And so to the extent a company is offering that service, it's a futures commission merchant and needs to comply accordingly and register with the CFTC. And I think what's most interesting as far as all of the cases that have been brought forth is the Yuki DAO case and the BZX case. And there are slides with lots of information on this case and some recent developments. But the key takeaways or questions at least were, how do you affect service on a DAO? Is a DAO a person that can be liable under the CFTC? And then who can be liable? And we found out from that case, yes, you can affect service from the DAO on a DAO. And it was done in a unique way by the CFTC by serving the help chat box and discussion board on the website. And can a DAO be liable under the Commodity Exchange Act? Yes, it can. And so now the question becomes, who can be liable? Is it just governance token voters, or is it anyone who holds a governance token? Those are a lot of interesting issues that developed and continue to develop from that Yuki DAO case in California. So there's plenty of information on the slides, like I said. There's also state action and a lot of private actions that we didn't get a chance to get into. The most, I think, interesting being the New York Office of the Attorney General case against KuCoin, where for the first time, it was alleged that Ether is a security. We've seen the SEC chair, current chair, be very hesitant about that, making that determination, refusing to answer questions in Congress. We've seen prior SEC directors state that Ether is not a security at certain periods of time, given certain periods of time, and so that's an interesting case to follow along with as well. And then lastly, all of the private litigation and fallout from FTX There's been a lot of class action suits that have been brought forth with interesting theories regarding NFTs being considered securities. And so to the extent that anyone is counsel to a company that is an NFT platform or is issuing and minting NFTs, or even developers that are developing NFTs, those cases deserve time and attention as far as the claims that are being brought, because I think there's a lot that can be done to defray those claims which are essentially state law securities violations. And so if you have any questions about that, please do reach out to us. But I think we're out of time and just want to answer some questions here.
Yeah, for sure. And Tyler, I think I'll maybe pitch this one to you, but one of the questions is, if the token is a security, then is it nothing more than a financial resource rather than an asset to be distributed after separation or divorce? And then the real question is, how the family courts considered the tokens or exchanges from the perspective of kind of a legal side. So I'm happy to let you take that one and jump into it if you want.
Yeah, I think, the asset, regardless of the token, regardless of whether it's a security or not, has a certain value to it as property. And so for divorce court purposes, I don't know, not a divorce attorney, but I don't know that, that distinction of security versus not really would matter, because you can attain that value as long as it's on one of the major exchanges. If it's not listed, then it's a little bit more difficult. But that's the same story with private and public stock as well. So you have the exercises to go through to do value determination for those assets. And so I think there's an analogy there, or an analogous procedure there to determine that.
Yeah, I think also building off that, because it's an interesting question, is if, for example, in the exchange cases that I was just talking about, the SEC is listing all of those tokens, right? And then you get into a separation or divorce, and it turns out that one of the parties has like a substantial amount of one of those tokens. Again, the issue is going to be that the family court is probably not going to have any authority that they can rely on, or any clarity that they can rely on to say that that is in fact a security, and then go from a procedural standpoint from that perspective. And so all that is to say is that, like, it's so nascent and early on that a lot of the more traditional courts are very much looking at the assets as strict commodities, and really not really getting into that many substantive questions around securities. Again, that will change over time as we get more clarity, but is very much a byproduct of some of the uncertainty that we have due to, not just solely due to some inconsistency from the governmental agencies. I know I bashed them a little bit too much, but maybe some more clarity from Congress as well at the federal and state level. So
I think that's all the questions we have.
Yeah, there's another one. One thing was just about the fraud cases, because we didn't touch on many of them. I mean, there's some fraud claims embedded in the Binance case for sure, but we have been in court and litigation with kind of claims of fraud on both sides in relation to companies that have issued assets or issued tokens, NFTs, things like that. And it's really important to note that there's a lot of interplay with how not only the asset is potentially categorized, but also the information that went into why somebody was able to access it. That good kind of dovetails back to a point that Tyler made earlier, that there is a lot of misrepresentation, a lot of potential fraud, and we have a lot of cases that are ongoing in relation to fraudulent schemes that were intentionally set up. So we're not even now in the realm of saying, hey, it's not necessarily ambiguous whether there was fraud. There is in fact fraud claims here, and as a result, we have to distinguish what the types of assets were, what type of responsibilities did the issuer and or provider or those operating the scheme provide to the prospective purchasers, and so on and so forth. There's also a lot of technical aspects about that process as well that make it a bit complicated, but those are ongoing for sure from a case perspective.
So Michelle says, in response to my description of how the asset would be treated in divorce, she says in Australia it's different, financial resources not in the pool of assets to be split, but they're watching the US closely. Yeah, Michelle, we represent a lot of companies, and sometimes those companies get requests for information regarding the assets that are held by the founders, or some people on the cap table in divorce actions. And so we've dealt with that in the past and would be happy to speak about that. And yeah, there's a lot of questions that go into it. You know, when is the asset valued? These assets fluctuate in value so frequently. You know, how do you strike a price for that asset if it's owned by the company and not directly by the individual? You know, what's their share or portion of it? There's a lot to dig through and unpack. So happy to speak with you more about that.
Without a doubt. All right, that is all the time we have today. Thanks everyone for joining in. Again, feel free to reach out to us. Our contact information is on one of the slides, so no problem, no questions that we won't be willing to answer. So thanks everyone. Thanks for Mondeck for hosting, and we appreciate it, and have a